I don't really have an awesome answer. You came to our Jack and Jill shower, and I remember seeing you and going, "Damn, is that John? Or did that thing eat John?"
I had kids, okay? What can I say?
You ate your kids?
It's not a conservative or a liberal issue.
Right.
It's a democratic issue.
I mean, no one disputes today that race is an immutable characteristic, except Michael Jackson. Why we were going down that rabbit hole, because it takes me so long to actually say something that I forget why we were actually saying it. I think you have to conclude that the Jew has to bake the Nazi cake. No more racism!
Hello everyone, and welcome to a very special episode of Commoners Podcast. Today, the confirmation hearings begin for President Trump's Supreme Court nominee, Neil Gorsuch. This week, we sat down with our good friend Chris Gavs to discuss the politics and history of the Supreme Court and the Constitution, and also what effect Neil Gorsuch would have on the direction of the court. Chris is a third-year law student at Suffolk University in Boston who has a particular interest in First Amendment law. We apologize for the quality of the audio on Adam's feed. He was having some problems with his mic, but nevertheless, we hope you enjoy this interview as much as we did.
Mr. Gavrielides, how are you?
I am excellent, John. Thank you for having me today.
Thank you for coming on. Why don't you introduce yourself to our listeners?
Sure. My name is Chris Gavs. As you said, I am a third-year law student at Suffolk University in Boston, and I am very interested in all things Supreme Court, law, politics, and, as you said, particularly the First Amendment.
What is it about the First Amendment that interests you so much?
Well, you're going to love this, but I have a really strong interest in religious liberty. That was actually my motivation for pursuing a law degree, and it's something that really gets me going, and so I really do enjoy discussions about, Hobby Lobby, RFRA, all those wonderful things that cause a lot of dissent around the country.
So you're a fan of justices like Gorsuch, Scalia, etc., Clarence Thomas?
Yeah, I find myself aligning with them more often than not.
So before we get into Neil Gorsuch himself, a lot of our listeners probably aren't super familiar with the Supreme Court, and especially listeners who are not from the United States. So I thought Adam had a few questions for you regarding the Supreme Court in the United States, maybe how it's a little different than other countries. So Adam, why don't you go ahead?
Right, so here in the UK, our Supreme Court, that ancient and noble court, founded in 2009, is a Supreme Court that is politically and ideologically neutral. It's kind of designed this way so there isn't actually much political say in who the justices are. So within the UK Supreme Court setting, it's actually a commission, a judiciary commission formed out of the four nations plus the president and vice president of the Supreme Court itself that actually nominate the candidates, and then the final candidate is chosen by the Lord Chancellor, essentially the equivalent to the Attorney General. So it's not a very political process. It's actually almost a self-managing judicial process. So just in terms of the history of the Supreme Court of the US, at what point did the Supreme Court become a politicized entity? Because right now there's kind of obvious conservative and liberal sides of the Supreme Court that coincide well with the Republican and Democrat parties.
Right.
Has that always been a part of the system, or is it a fairly recent phenomenon? If it's recent, when did it happen?
Sure. Yeah, a couple of things. Well, in one sense, it's always been somewhat political. If you go all the way back to George Washington and John Adams and Thomas Jefferson, you look at their personal philosophies. And I'm by no means an expert on those, but you have the Federalists and the Anti-Federalists and eventually the Whigs, all sorts of different places where they came from in life. And each of their appointees to the Supreme Court brought something unique and different to the bench. Fast forward to more modern times, you'll see in more recent years a lot of controversy surrounding any nominee to the court. And I think if you go back to maybe Justice Scalia, I think, was one of the last Supreme Court justices to be nominated in recent history without a lot of controversy surrounding him. I think after that, starting with maybe Justice Thomas.
What year are we talking about with Scalia and Thomas?
Scalia was 86? 86, 88?
I think it was 86.
Yeah, 86.
Yeah, it was
like
decades ago.
Sometime during the Reagan presidency. Although I do remember Justice Thomas to the hour, actually. He was appointed and confirmed by the Senate on Tuesday, October 15th, 1991, at about 8:00 p.m. And I know that because I was born at that exact moment.
Really?
I was. But his confirmation proceedings were shrouded in controversy because of the Anita Hill scandal, which we don't have to go into detail now, but I think that's about the time.
Go ahead. What was the Anita Hill controversy?
It was this, the typical run-of-the-mill sexual assault accusations, and obviously they never went anywhere, otherwise he would not be on the Supreme Court right now. But anyway, all that to say that it was around that time, I think, in my non-expert opinion, that things became a little controversial after that point, and you started seeing more resistance to Supreme Court nominees. So Scalia, I think, was close to unanimous, if not unanimous, and then Kennedy was the same. And then starting with Thomas, he barely passed the Senate with a 52 to 48 majority, I think, something like that. So it's all been downhill from there.
See, it's surprising to me that Scalia would be the last nominee to basically not generate any controversy, because his style and his judicial philosophy seem more to be more partisan or more conservative, I would say, than others.
I think that's true, but I don't think you have to think back to what was known to the Senate at the time. So that was a different time before he had issued any of his more controversial rulings, back when he was on the D.C. circuit. And to some extent, you have to keep in mind that these judges, their approach to the law absolutely changes between the time they're on a circuit court to the time they're on the Supreme Court because of stare decisis. They have to adhere to what the law says, and that includes coming down from the Supreme Court, what the precedents say. And so when you become a Supreme Court justice, all of a sudden you're the primary rulemaker. Wow.
You're one of 9 primary rulemakers.
Yes. And obviously that gets into the philosophy of, do you say what the law is or what it should be? And obviously originalists like Gorsuch, Scalia, all say, we're supposed to interpret what the law actually, what it says, not what we want it to be, essentially. So all that to say that when you're on the D.C. circuit, which is where Scalia was, where Ginsburg was, there's a difference there between how they conduct themselves and how they write their opinions and whether they defer to the higher power or be more creative.
Right, because if you're on any sort of lower court under the Supreme Court, you need to follow Supreme Court precedent. You can't overturn a Supreme Court ruling.
Absolutely, and I'm sure you know recently an Alabama Supreme Court judge, and this isn't even the federal court, an Alabama Supreme Court justice, I don't actually know what ended up happening, but he was temporarily removed from the court because he opposed the Obergefell decision.
Now, will you be removed for even just openly opposing it? Or would you be removed for writing an opinion against it?
Both, I think. I think more so in the federal courts. If you come out and you say, I'm going to blatantly ignore Supreme Court precedent, I think that is what they might call bad behavior under the Constitution, because you're essentially saying, screw the law. I'm not going to do what the law says.
One of the reasons I think that I can see that it's such a politicized thing when you have a Supreme Court nominee is that Supreme Court nominations are for life. They are lifetime appointments. You cannot be impeached from the Supreme Court, and you can only resign or die, essentially. So,
you can be impeached.
You can.
For improper behavior. I mean, the Constitution says that they shall enjoy life tenure in good behavior, during good behavior.
But that hardly ever happens.
I don't
think that's ever happened.
To my knowledge, it's happened once or twice.
Okay.
And that's not in recent memory at all.
Right. So, essentially, somebody who's only in office potentially only for 4 years, maybe less if they're impeached, could have a 20, 30, 40-year impact on the Supreme Court and on the direction that the country travels. So if you have a really, really conservative or very, very liberal president and they nominate an extremist on either end and they're 50 years old, they could be on the court for 30 years and they could be influencing public policy for years to come. So I think that's sort of another reason, another point of contention when it comes to the politicization of these nominees.
So essentially there's a lot at stake. And
absolutely.
It is worth fighting over.
Yes.
Which is why the Supreme Court was probably the biggest issue during the 2016 elections, followed closely by healthcare, of course. I think all the exit polls showed that was the number one important issue.
That's why a number of my relatives voted for Trump.
I mean, that's ultimately what it came down to. I'm not voting for Trump. I'm voting for his nominee to the Supreme Court.
Yeah, essentially most of my Christian friends that I get to chat to, especially those that did end up voting for Trump, that was essentially their only motivation. I've found very few of my Christian friends were actually supportive of his rather negative rhetoric. It was more for the Supreme Court pick. But
for some, it's just a scapegoat to not vote for Hillary Clinton. They need to find an excuse to vote for Trump over Hillary.
I mean, I would definitely say that that's true, even though I don't think that I don't think that a Supreme Court nominee can necessarily always be the turning point on somebody's whether you're going to vote for Clinton or Trump. Because I mean, look at Justice Kennedy, who was nominated by Reagan. He ended up turning his back on the conservatives when it came to something. What was it? Was it Planned Parenthood v. Casey?
Planned Parenthood versus Casey was probably one of the biggest, at least early on.
Right. And so he was nominated by a conservative president, a very conservative president, and then ended up siding with the other side on an abortion case.
That's right. And actually, he was on the majority. Well, obviously he was on the majority, but he was on the other side, on the dissent side before. Well, in the 11th hour, he essentially had a change of heart. And he went, I think it was to Rehnquist's chambers, and he says, "Hey, you're gonna hate me, but I need to make it. I need to change my mind on this. This is So a lot of conservatives hate him for that."
What specifically did that ruling allow for? What did it rule on?
Planned Parenthood versus Casey, in the words of that opinion, reaffirmed the essential holding of Roe versus Wade, but it reformed how the courts are supposed to approach that issue going forward. So it essentially said that the decision of a woman to terminate her pregnancy pre-viability remains a decision between her and her doctor. After the point of viability can be regulated by the states and even banned, except in cases where it would interfere with the woman's health. Roe v. Wade was a little bit more regimented than that. And the court in Casey really recognized the problem with having a structured trimester system that Roe set up. Roe basically said, you have the first trimester, you can do what you want. Second trimester, states can regulate unless it's the woman's health. And then third trimester, basically, the states have the right to outright ban abortions. And they did away with that regimented system and just made it a pre versus post viability system.
Right, but Kennedy made no friends by switching sides on that issue.
Not on the right, anyway.
Not on the well, exactly. But that's an instance of when you think you have a very conservative justice.
Yes,
and it doesn't always work out that way. Before we get into Gorsuch, there are a number of political philosophies and judicial philosophies that are used in interpreting the Constitution on the Supreme Court. So what I wanted to ask is, what can you tell us, first of all, about the composition of the Supreme Court right now? So the justices we have now, as much as you can about their personal philosophies, and then overall, as a sum of the parts, would you say that the court leans more conservative or more liberal?
So back when Scalia was alive, you had Roberts, Kennedy, Thomas, Ginsburg, Breyer, Alito, Sotomayor, Kagan, and of course Scalia. And you really had 4 versus 4 in terms of the conservative and the liberal bloc in the court, with the tiebreak vote in Kennedy, depending, of course, on what kind of issues you're talking about. If it's touching social policy in any way, as time went on, you saw that Kennedy was more a vote with the liberal bloc. Mm-hmm. But that wasn't always the case. It really depends on how you paint the issue. And so someone like Kennedy went from Planned Parenthood versus Casey to eventually deciding Gonzalez versus Carhart in favor of the conservative side of the argument, in which they upheld the Partial Birth Abortion Ban Act. Oh. He's an example of someone who routinely, you really have to be careful with Kennedy, and it's going to come down to him and how he views the issues. And in that particular case, it was painted as a woman's health issue, as opposed to a woman's rights issue. So whereas Planned Parenthood versus Casey was about, okay, are we looking at enough for the woman's health? It's not just about the woman's right to choose. It's not about weighing the woman's life versus the baby's life. It's if there's any risk to the woman and the state's not counting that into its calculus, then Kennedy's going to be a vote to strike down that law. Wow. And by the time Gonzalez came around, people kind of figured that out. And they painted the issue more as like, okay, look, this act is really taking these issues into account.
So a lot of it comes down to the argumentation of the lawyers.
Yes, absolutely. And it definitely depends on the legal issues at stake in the case. And that's just with Kennedy. So you have Kennedy there who sort of flip-flops between, I wouldn't say flip-flop, he thinks. You know what I mean? It depends on the issues being presented to him, and you can't peg him down, which I can appreciate that about him. Mm-hmm. He's not the sort of person you could say, okay, this is a case involving X issue. He's absolutely going to vote with the conservative bloc on this one. In more recent years, I think Roberts has sort of gone that way as well. He's another one who is sort of The conservatives had him pegged down as an originalist, as someone who was going to be friendly to their cause, and then you get the Obamacare decisions, and the Affordable Care Act remains intact to this day. But generally speaking, Roberts is going to be on the conservative bloc, and you can, of course, point to certain opinions and dissents like the one in Obergefell, where he issues just this scathing dissent against the majority, and basically says, if you're in favor of this decision, you can celebrate many things, but don't celebrate the Constitution because it had nothing to do with it. Wow. And I think when it comes to judges issuing opinions on really high-stakes issues, you really don't get much more scathing than that.
Yeah.
Unless, of course, you turn to one of Scalia's dissents. God rest his soul.
For as much as I cannot stand Scalia and the opinions that he held, the way he expressed them was great.
Pure applesauce. And then Thomas and Scalia were really two peas in a pod. I think they voted together on about 90 to 95% of opinions. If you ever saw a Thomas dissent to a Scalia opinion, it was a very rare occasion. And then, of course, you have the liberal bloc, which consists of Sotomayor, Kagan, Breyer, and Ginsburg, and they're more often than not, at least on the controversial cases that come down 5-4, they're always going to be together on those ones. But there's some hope, even though you sort of see this a lot of these cases coming down 5-4. You have cases like Town of Reed versus Gilbert, which is a case out of Arizona involving church signs, actually, and that came down 9-0 in favor of religious liberty in that case. And so you do see these glimmers of hope where the court can come together, and it's not about politics, it's not about pursuing agendas, and this is really one of those cases where I sort of say, okay, there's some hope here for the future of America, that we can actually think logically about these issues and not hate on one side or the other and just say, okay, this is right.
My question, kind of piggybacking off of John's there, was, and I think you kind of partially answered it there, but is it actually healthy to have that liberal-conservative divide? Now, obviously, there is leeway as time goes on because judges do tend to move their opinion, but, on kind of a con side, I guess, it just kind of adds fuel to the bipartisan fire a little bit. As you said, it's a 4-4 split with a little roving justice every now and again. But on the pro side, it actually does functionally represent the bipartisan nature of American politics.
Yes, absolutely. It does represent the bipartisan nature of American politics, that's for sure. The problem there, like you said earlier, is that you can have one of these judges on the court for 20, 30, 40 years. 40's pushing it. I don't think we've had one that long, but pushing it.
Admittedly, yes.
A good chunk of American history.
Yeah.
I think in that sense it's kind of dangerous because ideally these judges are interpreting the Constitution according to maybe a specific philosophy, but ideally they're not being political. They're just interpreting the Constitution the way they think it's actually intended to be written, whether they're looking at it from a textualist perspective or, okay, yeah, we're looking at the words, but they've changed in meaning over time. And so depending on where you're coming from on your philosophy, ideally they're being true to the law. And so from that perspective, I think the framers at least never intended it to be as political as it is today. And I think it has become somewhat unhealthy in recent years.
Well, is there a way that you would see fixing that? Would it take simple reforms, cultural change? Does it take another amendment? What would you suggest?
I think that probably the biggest is a cultural change. We need an attitude change in this country towards politics in general. Until we see the whole red versus blue, Democrat, Republican, as soon as all that rhetoric entered into the fray, the Supreme Court was a casualty. And it didn't happen immediately. It happened slowly with one presidency after another, and over time, and these controversial social issues have just really been the driving force behind this and have really required the court to become more political because presidents are looking at the issues and saying, okay, I need to appoint this particular judge who will advance this policy. I'm not saying they do this overtly, but I think there's some pressure on them to appoint judges who will do what their party's base wants them to do. And so that has driven it to become more political. And unfortunately, I don't think you're going to see that go away anytime soon.
Well, that's depressing, but you
don't
mentioned...
mean to be a downer.
it's just reality. You mentioned textualism.
Yeah.
Now, both Scalia and Gorsuch, from what we know, are textualists, yeah?
Yeah. Well, let's break down that word a little bit because people kind of... what do you mean by textualist?
I mean the judicial philosophy of textualism historically. Could you expand more on that? What is it?
Sure. Well, just about judicial philosophy in general, there are a couple of main schools of thought from which you get a bunch of different terms being thrown around. And just to sort of outline those two very quickly, the first, which we won't really be talking about today, I know, is a view that the Constitution is a living document, that it changes, that the words as they were used back in the 1800s, it's not feasible to interpret them as they were meant solely back in that time period. And over time, the words and their meaning change over time, culture changes, and you have to interpret the Constitution through that lens.
So you determine it based on the current culture versus...
Well, you certainly keep that's part of the calculus, absolutely. And I'm sure someone who supports that philosophy more than I do can probably do more justice to that view. I of course am more...
It's the right one.
Naturally.
Go ahead.
So I adhere to more of an originalist view. And originalism is where you sort of see, it's like a big umbrella. It's been used as an umbrella term to encapsulate many others, but you really have to stop and appreciate the fine differences between these terms. When we talk about members of the court who are originalists, we often throw in terms like textualism, original intent, original meaning, strict constructionism, and I'm sure there are others out there as well. Just to break some of these down further, original intent, for example, looks to what the legislature specifically wanted to do with a law or constitutional provision. Original meaning, on the other hand, looks into how the plain words would have been understood at the time they were written. Many people think originalism and strict constructionalism are interchangeable, more or less. Mm-hmm. That really doesn't do the terms any justice, and in fact, Scalia would probably roll in his grave. So for a strict constructionist, the reading of the text is really the start and finish to the inquiry. For an originalist, on the other hand, you start with the reading of the text, and then you go on to look at things like context, intents, legislative history, and so forth. In the words of Scalia himself, he was, quote, not a strict constructionalist, and no one ought to be, because it is a degraded form of textualism that brings the whole philosophy into disrepute.
Wow. Strong words.
Well, from Scalia himself.
Yeah, of course.
Of course.
So then Scalia would describe himself as a textualist.
Yes, but more specifically an originalist.
More specifically an originalist. And you think that Gorsuch would fit that mold as well?
I do, yeah. I think they come a lot from the same bread and butter.
So is it fair to say that Gorsuch is Scalia 2.0? As a lot of people are calling him.
Some have called him Scalia 2.0 because he does carry somewhat the same philosophy, but he delivers it with a more modern touch. You're not going to see some of the Scalia flair to his opinions. You're going to see a different writing style, certainly, a very coherent and logical writing style.
From what I've heard, he's an excellent legal writer.
He is.
But I guess my question is, are there opinions that we can look at to give clear examples of originalist philosophy, judicial philosophy, so we can kind of get a handle on what like we said earlier, Gorsuch cannot overturn, in his current capacity, cannot overturn Supreme Court cases, so we have a limited view into what he would decide, right?
Yeah, that's
he's
fair.
given to an extent, if he's given the power of a Supreme Court justice. So how could we expect an originalist philosophy to play out in the Supreme Court?
Well, one case I would really suggest, and to some extent this happens in every single case, especially the ones that are 5-4. If you see a 5-4 case come down, read it closely and see how the majority really interpreted the statute. But a fairly good example would be District of Columbia versus Heller. So that was a 2008 case, 5-4, on a handgun ban statute in D.C.
Yes, I remember.
It really came down to a battle of the philosophies. So you have both sides basically trying to determine, okay, what do the words well-regulated militia being necessary to the security of a free state, what does all that mean? And so you had both sides really digging into the legislative intent, however much of it is actually available from 1780, 90, whatever it was. And you have them really trying to interpret, what did that word literally mean back then? And how was it referred to in social context? Did it refer to a police force, something that might look like a National Guard today? Or did it literally refer to each individual citizen having the right to defend themselves against an oppressive government? Mm-hmm. But a lot of people, and I'm not necessarily saying that I'm married to this idea, but a lot of people say that if you lack the ability to defend yourself against the government, then your other rights really don't. They're really just whatever the government chooses to let you continue to have. Mm-hmm. And so from that perspective, I guess it sort of makes sense to say that if you arm the individual citizens, then the government is sort of reminded that this is a country ruled by the people, and we're not, and you're not the caretakers of the people. The people basically permit the government to continue to exist,
Right.
and they don't need to cede this right to the government.
And so obviously the conservative bloc would lean more towards that, and the liberal-leaning bloc would lean more towards a militia, literally a well-regulated group of individuals.
Correct.
Yeah. So we could expect then Gorsuch to fall on the side of the conservative bloc there and view it as an individual right then.
Absolutely. And Scalia wrote the opinion in D.C. v. Heller, and if you flip-flop things and you put Scalia back on the D.C. circuit at the time and Gorsuch onto the Heller court, then you absolutely have Gorsuch writing that majority opinion instead.
Well, good to know. So
yeah.
if any second,
And this is coming
if
back
any Second
around.
Amendment cases come up, we know.
Yeah, they're going to, because you have states right now passing assault rifle bans. They're popping up all over the place, and it's going to be a very similar issue.
Great.
But just to sort of dive even deeper into this whole textualism versus living constitution debate, there are many opinions looking back where people try and point out flaws with originalism. And one of the most popular cases used to do that is Brown versus Board of Education.
Ah, yes.
Which please describe for those of us that might not know what that is.
This is the famous case that reversed Plessy versus Ferguson, the infamous separate but equal case, which will go down forever as one of the worst opinions in U.S. history. I can probably think of a few others to add to that list, but I won't for your sake right now.
Is this essentially racial apartheid in the public school system? Okay.
Right. So to get back to your question, I'm sorry. Brown versus Board of Education desegregated schools. And that was the 1950s case. And basically the U.S. government had to step in, and Eisenhower actually had to send in the National Guard to enforce the Supreme Court's rule in that case. Just a little bit of fun history. The state basically said, no, we're not going to recognize the Supreme Court's authority on this issue. You can desegregate over our dead bodies. And so Eisenhower sent in the National Guard and said, okay, we're going to take you up on that. So Brown versus Board of Education is this school desegregation case. And as we know, things weren't magically back to normal after that. And by back to normal, I mean normal for the first time ever. Things weren't magically normal after that. The Supreme Court had to have its order enforced by the president. And then you have years of racial reconciliation, which have obviously, and we can all agree on this, obviously have not concluded yet. Obviously. No, I don't think any conservative can
realistically
claim with a straight face that racial tensions in this country are anything short of screwed up.
Right. So the outcome of the decision was good.
Yes, absolutely.
Where in here is the example of originalism gone awry?
So whether originalism is compatible with Brown versus Board of Education, that question was posed to Scalia himself more often than a lot of others. So much so that he once said, "Waving the bloody shirt of Brown again, eh?" But the truth is that an originalist or textualist is easily a vote with the majority in Brown, simply based on the 14th Amendment. The Reconstruction Amendments were specifically intended to end and prohibit policies that were built off of the false presumption that the white race was somehow superior, and that included segregation. It takes no judicial activism at all to say that the 14th Amendment was intended to do as Brown ruled in that particular case. And Scalia used to point back to Justice Marshall's dissent in Plessy versus Ferguson, which recognized that years before, that the Constitution was never intended to treat people like this. And eventually, we finally got our shit together and figured that out. So
then you would say that the arguments against originalism in that case are invalid.
I mean, I would. Of course, it's up to you whether you want to accept or reject that. And people smarter than me, of course, would say that's just stupid. You're taking our side, if anything. You're taking the more progressive view of that issue.
Right.
But I think Scalia would be one of those people who would say that when you're faced with some issue like segregation, that this policy of segregating schools clearly needs to end. If you have a philosophy that can't get you there, I mean, I'm not a judge. Get there somehow. Find a way to make that work, because if you're looking at something that's such a blatant evil, then if your philosophy can't get you there, then maybe it's not perfect. No.
So you're saying that Scalia, Gorsuch et al. Would basically say originalism with moral exemptions?
No, I'm not saying that. I'm saying that for people like me who aren't as smart as these guys, who can't maybe find a way to justify that philosophy, you have to know what the right thing is. And that's just for us in everyday civil society. We have to be able to take our theories and put them on the side when we find a situation that doesn't line up with it, but we know there's some moral imperative here. And I guess that goes to, I know this has been some Christian influence in this circle, having all three of us having gone to a Christian college, and that's really where you get down to the morals of what is just. And that gets outside the realm of the judicial philosophies pervading the Supreme Court. But, of course, Scalia and Gorsuch would definitely be a vote in favor of the majority in Brown v. Board on originalist grounds.
Well, good. At least we can agree on that.
Oh, we can.
That's annoying. Because essentially it does come down to relative morality in the end, in a sense, which really frustrates me, because then it's to hang with any particular judicial philosophy on the sake of a personal view of morality, which, within a proper legal perspective, I'd say is ultimately going to be subjective.
Right, and that's why there's such a strong resistance to deviating from your philosophy when arriving at any position. And as a Supreme Court judge, that's absolutely true. You really can't be deviating from your philosophies whenever you think it's just the right thing to do. So I'm just speaking to you guys as another person living in this world who knows, presumably, right from wrong.
Presumably.
Presumably, and I assume then that is the attitude behind Roberts being so upset about Obergefell, is that there's arguably not constitutional basis for it, but people are letting their personal feelings of what they believe to be right and wrong getting in the way.
Right, so what you have there is this case where, the 14th Amendment, equal protection, obviously means that the states who recognize marriage, all of them, have to recognize marriage for anyone, whether you're same-sex or opposite sex. Meanwhile, you get people on the originalist side saying, because the Constitution says nothing about marriage, it's not about the equal protection side, it's about the fact that marriage should come down to the states themselves, and the people in those states. It needs to be a matter of local policy as to whether or not we're going to recognize same-sex marriage. So Obergefell is another great example of an originalism versus more progressive view of the Constitution, because the 14th Amendment can be widely applied to almost any conceivable situation, especially on social policy, whereas the more conservative judges are going to look at that and say, well, because it's not in the Constitution, we're going to look at the 9th and the 10th Amendments. So the 10th Amendment being those powers not reserved by the Congress are reserved by the states and then to the people respectively. And then the 9th Amendment, which says that just because it's named here doesn't mean that the people don't have those rights. Just to say that in a nutshell, because the 9th Amendment text itself sounds really confusing.
We appreciate it.
Of course. Layman's terms.
So both Adam and I are pretty liberal. So we would look at something like Obergefell and say that is just, where the majority of the Supreme Court sided with us. And that's why I think we're concerned about somebody like Gorsuch, because we look at Scalia and we don't agree with him on much. I think the only time the only time I ever really agreed with him was what was the case with the flag burning?
Oh, that was Texas versus Johnson.
Texas versus Johnson. I think that's the only time I really truly agree with Scalia, because I'm more or less a free speech absolutist.
You know what he said about that issue? He said that if I were king, I would outlaw flag burning. But I'm not a king, and this is America. We have the First Amendment. And I love it. That's the kind of jurisprudence that I really love, and I'm glad that we can agree on something like that.
I agree on that completely. I think that,
we can be discussive of flag burning all we want, but it's speech.
Exactly.
Albeit symbolic speech.
But
I digress.
But liberals do have concerns about somebody like Gorsuch.
Yes, of course.
And I've outlined some here I think that we should get to. Money and politics.
Yeah.
So Gorsuch has come out and said that he thinks that giving money in a political campaign, even if it's a corporation, is a fundamental right. I'm wondering, and we have this whole idea, and we're talking about the 14th Amendment, and the affordances that are given to persons. And we have, corporate personhood as a legal principle in the United States, where we give certain 14th Amendment rights to corporations, which I would disagree with. Where do you know where Gorsuch falls on corporate personhood, and would he be in favor of something like a Citizens United?
Yes. No, he would.
Damn it.
He would. He's certainly not going to win praise from Justice Ruth Bader Ginsburg on that one.
Good.
She has, as you know, she's voiced such strong opposition to Citizens United that she said it's the one decision that she views as the greatest injustice of her tenure. I mean, obviously she was in the minority on that one. She was in the dissent. But they would absolutely be at odds on that one.
Good. Not to get off on too much of a tangent here,
Sure.
but I agree with her there. Because I think if you look at the system, the way it's set up, the problem is money in politics, fundamentally, I believe, is the core issue with corruption in our political system. When you have unlimited dark money from people, like yes, that's fine. If personal citizens can give money, that's I'm okay with that. But corporations can give way more than I can.
Right. You just have a problem with two people getting together and putting money in one pool and giving it to a political candidate.
Yeah, essentially.
Right.
Essentially. Well,
Right.
not well. We can talk about PACs all we want, but no matter how many people get together, we're not going to be able to put as much money into the system as the oil and gas industry.
Right. Exactly.
And
the
money influences policy, and you can see that.
And in fairness to you, it isn't a simple matter of you and me and Adam saying, let's combine all of our money and support candidate X for office. This is obviously, Fortune 500 company putting together a massive pool of resources from all of its profits and saying, we're going to buy this candidate. We're going to buy candidate Y instead, so that Chris, Adam, and John have no chance of winning this election. And there's a lot. I have a lot of sympathy for that argument. I think that it's a really good point. But I think we have to ask ourselves, at what point does this become a matter of thought control, of speech control?
So, yes, but since when does money equal speech, though? So here's a scenario for you. I go down the road and I pay a woman to give me a blowjob, right?
This is very unrealistic, John. You don't have that much money.
This has turned into a
You don't have
confessional.
that much money.
No, okay, if I do that and I get arrested for soliciting a prostitute, if money is speech, I can just say, no, you're infringing upon my First Amendment speech rights. I'm just telling you how much I like blowjobs.
Can you just tell me real quick how that's speech?
What are you talking about? How is it speech to give money to a political candidate?
It's pure political speech.
Okay.
One of the most protected classes of speech under the First Amendment.
For people. But why do we consider corporations to be people?
Do we? Or do we? What about the conglomerate parts of a corporation? The board of directors, the CEO, the people who make up the corporation.
Individually give money.
They could do that. That's very true. But on what basis are we saying that, or what level of wealth do we say you can no longer give?
I don't think it's just a
On what
level of
basis?
wealth. I just think there's a level of incorporation.
Yeah, I think it's more an issue of individuals acting on behalf of a particular institution, a corporation, whatever. One, I'd actually also like to get your thoughts, particularly in this issue regarding multinationals, corporations. So, for instance, you're not even necessarily talking about specifically American corporations that can get in on this particular legislation. You're talking about multinationals as well. Like Citgo out of Venezuela, I think that out of Venezuela, can also give money into the political system through this particular legislation. There just seems to be...
Now, that might be true, but I think you see that happening on both sides of the aisle, though. And I recognize that your point isn't that, okay, well, more of this money goes to the conservative candidates. I know that's not what you're saying, but I think that if you look at this as each corporation, is another actor in the political sphere, then who's to say what each individual actor here could and could not do, what they could contribute to, and if you look at them as I know you hate that idea, but if you look at them as individuals in this political realm, then why can't they give their resources to one candidate over another? Because we can talk about maybe buying candidates, but they can do it for both sides.
And I agree, and I think that should never be the case for either side. So if the ACLU wants to buy a politician, I would be against it.
No, sure.
I'm just against money. I would be in favor of universal public funding of campaigns instead of personal private money, because money corrupts. I think we know that to be a fact, and that's one of the reasons why we don't have a true party that really represents the people anymore. It's we have two sides of a corporatist coin, in my opinion, at least. I mean, there was a Princeton study that was done that literally found more often than not, I think it was 70% of the time, corporations and special interests get the legislation that they want, whereas that number is minuscule for what the public actually wants. So that's my concern, and I agree with Ginsburg there, where we would say it is a completely unjust opinion. The system in and of itself that we use money like that to fund the political system, that I find unjust. And so so as a progressive, as a liberal, I want all sorts of private money out of politics. So it's not a.
So what do you mean by all sorts of private money? Are we
All
just talking about all money?
All money.
You and me?
So you would advocate essentially for a publicly funded political campaign?
Yep.
Both sides or all sides?
Yes.
Oh, that's interesting.
Equally.
Yeah, I would back that as well. I've seen it work relatively well in Europe. I would like to see, particularly with the size of the states, how big those purses would have to be, though. I'm pretty sure that would maybe raise some eyebrows as to how much money you'd actually have to channel into that. But nonetheless.
Well, it would be a reformation of the entire campaign process, because we have such a long campaign process. It would be cheaper if we had a system where you can only campaign for a month, like in the UK.
30 days.
30 days. The campaigns are literally limited to 30 days. But we're getting a little far of a field, but I guess just sort of to pander to our listeners, because we do have a more liberal progressive base, and these are the things that concern them.
Absolutely.
So when we look at Gorsuch,
and they're fair concerns. Like, I'm a conservative, and anyone listening to this, I'll tell you, like, I understand these concerns and I sympathize with the worry you have of, okay, is this corporation buying this candidate? Are they controlling the elections? Are my candidates actually going to support my position in Congress? And I think that on a deeper level, this really comes down to the electorate itself. And I think I do disagree with your point, John, that nobody should have donate to. Are you saying no one should be able to donate to campaigns? Not even you and me?
Ideally, I wouldn't want that.
Okay. I mean, because I just think that is pure political speech. My ability to give money to this person I support because I want to advance their cause. Because you have to think about the resources that go into a campaign, getting the word out about people's different policies, and literally getting the candidates from A to B. It costs money to actually get these speakers on television, to get the word out about what their positions are. And it's different when you have a country that spans 3,000 miles and you have 350 million people here. You have to consider those factors as well. And I'm not saying we couldn't benefit from any reforms, and the UK obviously has different systems that we could possibly consider.
So I guess it just seems like the only fix, in my opinion, because of the current system that we have, where we are extending those rights to people. It creates a disproportionate. It creates a democratic deficiency, because you have the people with the most money are going to make the best out of the system. The people with the least money are not. You see what I'm saying? So if you want to if you want to let everybody give money but cap it at $27 like Bernie Sanders, then okay, that's fine. But when you can funnel money into these tax-free campaign
it's
vehicles,
influential,
like CPACs.
But ideally, it's influential in the sense that you just give these candidates resources to continue getting their word out there. And I get that that's a little bit idealistic, because more than that's going on.
Right, but
you know that some of the money is being given with certain attachments.
Well, here's the thing. I hated Hillary Clinton as a candidate. You could look at that and prove a quid pro quo, but I hated the fact that she was obviously funneling money through the Clinton Foundation. Obviously. And you saw that when she was in Secretary of State. There were contributions from foreign companies, and magically they get weapons deals. Like, seriously.
I know.
And it's not a conservative. Right. It's not a conservative or a liberal issue. Right. It's a democratic issue.
Mike, I mean, that's obviously illegal what she did.
Yeah.
Already, it's illegal. So, what's the solution there? Because we're not talking about campaign contributions there. We're talking about her channeling monies into a nonprofit organization in exchange for deals. So, I mean, it's a little bit of a different issue.
Right, but
your point's fairly made.
I just think that they
own her.
Right. But how does that not happen with gas companies and oil companies that are doing the same thing to other politicians?
And I sort of digressed from this earlier. I was trying to get to the point that I think it comes down to the electorate, because you have to understand these people need to actually, you and me, sorry, Adam, you can't vote in the United States, but we need to actually go to the polls and express our disgust with these people. It doesn't matter how much money is funneled into these campaigns. I mean, let's be honest. Both sides of a campaign are going to be very well funded. You have to expose these things. The media has to expose, like the Clinton Foundation, like they did. You have to make that public knowledge, and then the electorate has to actually consider these things and have to vote, not along party lines. They have to vote based on this information, and they have to determine, okay, is this person actually going to represent me, or are they going to represent Goldman Sachs? And that's the thing, and that's where it really comes down to the voter, and the voter has to reject these candidates. But the voter should be able to put as much money as they want into the system in order to help the campaign go forward. And then it's up to the other voters to pool against that voter and say, no, we're not going to let you do that. And obviously that doesn't always work. And I think we can say that if we tried the other system, then you might have limitations on free speech that a lot of people wouldn't be comfortable with. So it just, I don't know.
Perhaps maybe this is more of a retort to John, actually, is perhaps could it be considered for our side, John, a failure of the Constitution itself, and that if it is allowed under the Constitution and it cannot be overturned by the Supreme Court, then, isn't that a limitation that we more or less just have to live with?
Well, it's a good point, if it were written into the Constitution. It's not. There's nowhere in the Constitution that it says that companies have this sort of the rights of the 14th Amendment.
But it has been decided by the Constitutional Court that the Constitution does indeed say that.
Right, but actually this is a good segue into something like the Dormant Commerce Clause, where there are a number of things that are not in the Constitution that have been brought or inferred from the Constitution by the Supreme Court, such as the right of privacy, which we got through Griswold v. Connecticut, which was essentially the very first block that built up to Roe v. Wade. And you have the Dormant Commerce Clause, which I think we should get into. If Gorsuch and the originalists reject those sorts of rights that are sort of just pulled out of the Constitution willy-nilly, then why would you then say, oh, well, we're going to stick with corporate personhood, because that's nowhere in the Constitution?
Well, go ahead and define Dormant Commerce Clause for me.
Chris?
So the Dormant Commerce Clause is also known as the Negative Commerce Clause. So whereas the Commerce Clause itself, under Article 1 of the Constitution, expressly gives Congress the right to regulate interstate commerce, the Negative Commerce Clause is an invention of the courts that basically says, okay, states, you cannot pass laws that have a negative impact on interstate commerce. In other words, states will be prohibited from burdening or impeding the flow of goods from one state to another. And this is something that I don't think I know a single originalist who favors this position, because and I know we segued into this for a reason, but just to sort of touch on the philosophies again, is that the Dormant Commerce Clause simply doesn't exist in the Constitution. It's not there. It's read into it's sort of read into it as like a photo negative of the Commerce Clause itself. And Scalia, Thomas, and Gorsuch have been vocal opponents to it. And I think Gorsuch is definitely going to follow in Scalia's shoes on this issue as well. One case that Gorsuch weighed in on the 10th Circuit was Tarrant Regional Water District versus Herman, which went up to the Supreme Court in 2013. But the Supreme Court cited that, putting that aside for a moment, the 10th Circuit under Gorsuch basically held that the Dormant Commerce Clause did not prevent the Oklahoma Water Resource Board from preventing water exports from going to Texas. And it was affirmed unanimously by the Supreme Court. But it's an example of a case that's not exactly Dormant Commerce Clause friendly. So you see examples like that where Gorsuch really comes down hard on that doctrine.
So then, would Gorsuch then come out similarly against rights and previous court decisions that do find kind of shadow rights or shadow laws within the Constitution.
He certainly wouldn't be in favor of reading in new rights if that's what you're implying.
Yeah,
I think you brought up Griswold versus Connecticut earlier, the privacy case.
Well, I mean, Scalia himself said that there is no right of privacy.
No, it's not in there. It's not actually written in there. It's been inferred from the First, Third, Fourth, Fifth, and Ninth Amendments, and 14th. But it's not actually written in there, and you can make the argument that I think the strongest argument comes from the Ninth Amendment. Personally, I think that if you're going to look that far into the First, Third, Fourth, and Fifth Amendments, you can read anything into those. But to say that there's a right to privacy derived from the freedom of speech, because of the freedom not to speak, the freedom to have privacy over your ideas, then I think you're really stretching what the actual plain words say, and that of course comes down to a debate between which judicial philosophy is correct on this issue. But of course, there's the Ninth Amendment, which says that the rights not enumerated here are retained by the people, and one could say that does include privacy, but specific, in terms of express terminology, it's not in there.
So then, what is the delineation between a right that's not in the Constitution, that's inferred from it, that you would keep, versus one that you would not? So I guess the larger question comes down to his judicial philosophy, because if he's an originalist and a textualist, and he doesn't want to read in extra rights to the Constitution like Griswold did, and like the Dormant Commerce Clause does, then why would he be okay with corporate personhood when that's not expressly written into the Constitution either?
Well, I would say that a true textualist would never read a right into the Constitution. Because first of all, they already exist. We already have those rights. And that's what the Declaration of Independence really says. It doesn't say that the government has a right to... It doesn't empower the government to give us rights. It recognizes that we already have them. And we're basically putting a government in place to safeguard those rights. And which is why the Constitution was really careful about not enumerating a specific Bill of Rights. In fact, that was one of the biggest oppositions to the Bill of Rights, is that they eventually were concerned with, well, if we say you have the right to freedom of speech, religion, press, the right to bear arms, the right not to have soldiers quartered in your home, etc., if we say that, then are we saying by implication that everything not specifically listed in the Bill of Rights is therefore up for grabs by the government? And the answer is, of course not. We're just we're specifically saying that, okay, government, you really can't touch these rights. I don't know. It's interesting because that gets into the debate about enumerated rights. And there is some real concern there. If you start listing things that you can do, it implies that you can't do what's not on that list. So, being said...
Is that an inherent flaw of originalism then?
No, I don't think so. I think it's just a risk that the framers took when they passed the Bill of Rights. But I think that originalism is a way of looking back on that framework that they set up and interpreting what they meant from there on out. And originalism would say, of course the Bill of Rights wasn't intended to limit any philosophy really. I can't really imagine anyone saying that because it's in the Bill of Rights, or because it's not in the Bill of Rights, means it can't be anywhere else.
Right, like Obergefell. It's not in marriage isn't
right. So there's no right to marry in the Constitution, which is where you get into the 10th Amendment that says anything that is not outlined here is reserved to the states and then to the people respectively. And so that just means that the federal government is not going to put its hand in it. Now, of course, there's the fundamental right to marry, but before Obergefell, there was no fundamental right to marry. That doesn't mean that people didn't get married back then. Back when the Constitution was written, it still happened. It wasn't regulated by Congress.
It was an administrative thing. It wasn't a constitutional.
Which is why you have the dissent in Obergefell, which is saying it should be the states deciding this issue. And until 2015, they were.
Right. I guess then wasn't this philosophy prior to the Civil Rights Act the same? Leave it to the states because it's not enumerated in the Constitution, and so you are allowing completely unjust things to happen.
And, I don't know if everyone would agree with this particular answer I'm about to give, but I think that comes down to the basis upon which you are saying that someone can or cannot do something. So with Obergefell, it was same-sex marriage. The Civil Rights Act, you're prohibiting discrimination on the basis of sex and race, religion, you name it.
Homosexuality is not a protected class.
It's not. Well, it's it's technically still a rational basis issue. So if you were going to pass a law that allegedly discriminated against homosexuals, then it would technically be analyzed under rational basis rather than, say, strict scrutiny. That's true. Something that would be subject to strict scrutiny review would be a facially racially discriminatory law. And so you have like the Civil Rights Act, which basically says it's unlawful to discriminate on the basis of race and so forth, race, gender. In some sense, we are getting down to whether something is an immutable characteristic. And so by that I mean, and I'm necessarily referring to the famous or infamous Caroline Products footnote 4. If you're familiar with that case, it was basically, the case itself is not remarkable in any way, but the fourth footnote of the case, the court basically said that certain economic policies, if intended to disenfranchise a member of a particular race, for example, are inherently going to be subject to a heightened level of scrutiny. And from that, that one little footnote is spewed an intense amount of Supreme Court jurisprudence ever since. All that to say that an immutable characteristic. So Caroline Products, the fourth footnote, was getting at the fact that your race is an immutable characteristic. As much as we have certain people like Michael Jackson to fight against that, you cannot change your race. It's just part of who you are. And so to discriminate on that basis, you're not putting people in a position to actually change the thing you're discriminating against. It's illogical to discriminate on the basis of race because there's no science whatsoever to back any kind of accusation or assertion that one race is superior to another. And so between that fact right there, or lack thereof facts, and then the fact that you can't change your race, there's just so much wrong with actually discriminating on that basis. But
so the assumption then there would be that sexuality is or orientation is something that you can change.
Exactly. And that's why the left and the right, this is why this is still such a huge issue, is because a lot of people on the left will say, well, you can't change your sexual orientation. It's something you're born with, and it stays with you. And that's that. And so therefore it's an immutable characteristic. And it's like race and like gender, although gender, of course, is now no longer immutable, is it? Anyway, we can leave that for now.
Yeah. Let's not get into that.
And then, of course, people on the right say, no, it's a choice. You choose to be gay or not to be gay. And so that's obviously debate, and I frankly don't know the answer. But I will say that I think is, I don't know if it's really been expressly said, but I think that is somewhat, it's one of the tensions underlying this issue, whether homosexuality is immutable.
Right.
Or if it's a choice, then it's not. Because you could freely choose not to be homosexual. But then, of course, you have to make the moral judgment call that choosing to be gay is a bad choice.
Right.
That's the only basis where you could say that that same-sex marriage is illegal because it's amoral and because you can choose not to be.
So ultimately, it would be coming down to a moral choice.
Well, that's the side of the right. That's the conservative side of the argument. And so because that is still sort of, I mean, no one disputes today that race is an immutable characteristic, except Michael Jackson. But
not anymore. He's dead.
No, I know. Sensitive topic, I know.
Not really.
But people do still dispute this issue right here. And while it hasn't really come out in any formal way, I do think that is sort of one of the tensions here that people are going to have to wrestle with eventually. Is homosexuality, is it an immutable characteristic? Because if so, then we're going to have to bring strict scrutiny into this. And then any policy that adversely affects someone of homosexual orientation, any policy that concerns them specifically is going to be subject to a heightened standard of review. So, in some sense, these immutable characteristics that you can't change, and like the prohibition against discriminating against someone due to their religion, that obviously goes back to the First Amendment. And so you're going after these rights that have been deemed fundamental, and then you're introducing this new so-called right through Obergefell, however you want to pronounce it. You're bringing that into the mix now, and the question is, where does that fit into this narrative?
So it can be highly politicized because there is disagreement about whether or not being a homosexual is an immutable characteristic.
And you know that is in no way going to come down to the science. It's going to come down to politics, unfortunately.
Well, I mean, everything comes down to politics.
Right. And that's the unfortunate thing, is that there can be a conclusive truth about the world and everything in it, and then it doesn't matter what the truth is as long as the politics wins.
Which is another unfortunate side effect of the Supreme Court becoming so politicized?
It is.
Considering that we got onto religious liberties, particularly the LGBT right issue, seems to get a lot of attention from the religious communities in the States, particularly the conservative religious communities. So there does seem to be an ideological clash on the horizon. We've got two American values that are coming up. We've got the freedom of religion and religious expression, and then essentially you've got kind of a liberal freedom, essentially the freedom to be yourself and equal under the law as anyone else, no matter what that self looks like. So where does that lead us? Like, we've got two major competing values that are essentially head to head at the moment, and maybe how does Gorsuch play into that narrative, play into the debate?
Yeah, there's definitely a clash approaching. And I will say that on that note, just relating to sort of how his influence is going to play into this, sooner or later this is going to go before the Supreme Court. And just, I think it was a week or two ago, there's this case that actually came from Colorado called Masterpiece Cake Shop. Have either of you heard of it?
No.
It's in the same vein as Elaine Photography in New Mexico, Arlene's Flowers in Washington State. I forget the name of the case, but there was a case in Oregon about this Christian baker. And there are all these cases where a Christian photographer or baker or florist has declined to perform services for a gay wedding. In Masterpiece Cake Shop was the same exact thing. Obviously, cake shop, a bakery. This guy refused to bake and customize a special cake for a gay wedding, and he was sued in the Colorado, I forget what it's called, the Colorado Commission Against Discrimination or something like that, or Discrimination Commission, whatever it's called. The Colorado Civil Rights Commission, that's it. A complaint was filed with them, and they followed the litigation up all the way through the 10th Circuit, which affirmed the ruling against this guy and essentially held that he was in violation of Colorado's civil rights statute that prohibited discrimination against people in public places of public accommodation on the basis of gender identity or sexual orientation. And each of these cases has been decided the same way in every iteration from where it's came. So New Mexico, Washington State, Oregon, Idaho, you name it, every state where this issue's come up, it's been decided the same exact way, and each one has applied as a petition for certiorari and been denied. And this one was just denied about a week or two ago. And as you know, the Supreme Court is down to 8 judges right now. Had Gorsuch been on the court, I forget, I think it was a 4-4, it might have been a 5-3 decision actually to send it to deny cert. Mm-hmm. And I don't know for sure, but if it was 4-4, then that obviously would have gone the other way under Gorsuch. But eventually these issues are going to come to a head, and you're going to have Gorsuch on the court in the same position Scalia would have been deciding these issues. And eventually this is going to come to the forefront, and this obviously pits religious liberty against individual rights. And so you have the rights of the customer going into these bakeries, these florist shops, against the rights of the people who own these places. And the question is, who wins? Who carries the day? And it's a tough issue. Well,
is there then, again, maybe a fatal flaw in the Constitution in that it has kind of set up a predicament in which you have two arguably fundamental rights of the citizens coming head to head? I mean, how does the Supreme Court even weigh in on an issue? It has to take one side or another. Is there any way that it can appeal to both sides to guarantee the rights of both sides? Do we have to essentially dig into the specific context of each individual case?
Sure. So in some sense it's going to come down to context, but a lot of these cases look very alike on the issues, even if they deal with different kinds of work, a florist versus a baker. The issue is going to be the same. Can you, quote unquote, discriminate against someone based on their sexual orientation or gender identity in a place of public accommodation? They're always going to come up under the scope of public accommodation laws, which gets right into the state's civil rights statutes. So the issues are really going to be similar. The facts of each case, they might play into it to an extent. For example, in the Arlene's Flowers case in Washington State, some of the facts included that the florist had served this one particular gay couple for years prior to the event that led to the litigation. She served them for years and never objected to serving them. She knew full well that they were in a committed homosexual relationship. She took no issue with that, but that fact is helpful in looking at the later development that once this couple decided to get married and they requested her services specifically for their wedding, that's when she objected. And the reason that factual development is important to look at is because, at least from the conservative side, you're looking at this as an event, is denying services for an event rather than on the basis of their identity. And that's an argument that has been consistently rejected by every civil rights commission, by every appeals court and state Supreme Court and circuit court that it's come across. It's been continuously rejected, but I personally think that those opinions are incorrect for that reason, because you're looking at a woman like at this florist shop who for years serves this couple without any issues, and then all of a sudden she stops. Well, that tells me that she's not discriminating against them because of their orientation. She's choosing not to participate in this particular event, and the freedom to associate or not associate is something that has long been protected under First Amendment law. And I think one of the ways that we can really reconcile this is if we can recognize that this is an event, and this isn't an issue of rejecting people based on, and I'll grant you for the sake of argument that it is an immutable characteristic, that homosexuality is not something that you can choose. Even granting all that, though, I think we have the freedom in this country to associate or not to associate with certain events and with certain organizations. We see that all over the place. And I think that should extend to gay weddings. Because if you do have a bona fide religious moral opposition to this sort of, ceremony, then that is different from actually discriminating against these people based on something that is inherently tied to their identity. I think that's one way you can look at it. You can look at it as it's different in that sense.
The context does shift the perspective a little bit.
It shifts the perspective a little bit, yes.
How much do you think we can learn about how Gorsuch would decide a case like this when it comes to discrimination? And it's getting more, I think, to the First Amendment and to religious liberty and to the right of somebody who is religious to not give service for these sorts of events, the freedom of association. How much do you think that we can gain, how much perspective do you think we can gain on what Gorsuch will bring to the court based off of his Hobby Lobby decisions?
I think you can get a lot. I think you can definitely tell that he's going to be, he's a riffer guy. And there's really not much more to be said other than the fact that he's going to sort of fall in Scalia's shoes on this. And while Scalia didn't hear these particular cases that I'm referring to right now, because none of them have made it to the Supreme Court, I can guarantee you he's going to vote to grant cert on these issues if they come again. If Masterpiece Cake Shop gets, if cases like that come back up to the Supreme Court, he's going to be a vote in favor of cert, and then he's going to be a vote in favor of the baker, of the florist. And it's going to be on the basis of free exercise.
So you just mentioned RFRA, which is the Religious Freedoms Restoration Act. So this act was really a retaliation or a response to the Supreme Court decision, Employment Division v. Smith. Can you give us the facts of that case real quick?
So Employment Division versus Smith was a case about, there were a couple of Native Americans who were working at a private drug rehab organization. And it's kind of ironic, they were actually, using hallucinogens called peyote, and they were basically fired and denied unemployment benefits for using these drugs, but they argued that they were using them for religious purposes, and the Supreme Court rejected that argument, and it was a 6-3 decision, actually, written by Scalia, of all people. And he held that, the court held that one's individual religious beliefs can't excuse compliance with generally applicable law.
Well, we found it. The second opinion written by Scalia that I agree with.
How many are there? Exactly. Probably
just
two.
Two. Just two.
Just two. How about Chevron? What do you think about that one?
I don't know enough about Chevron to comment.
Okay.
Generally applicable laws.
Yes.
Now, what constitutes a generally applicable law? So with Hobby Lobby, when you have the ACA mandating coverage for birth control, for instance, to employer plans, is that not a neutral, generally applicable law? Like, I'm really trying to understand this. Where is the argument that it's not? Like, how are the owners of Hobby Lobby's First Amendment rights being violated? Because this was a Gorsuch's argument, essentially, is he sided on upholding the Religious Freedom Restoration Act, at least on a federal basis. not applying it to the states.
Mm-hmm.
So where is the line there? Like, what is a generally applicable law or not? I find it very hard to believe that that the owners of Hobby Lobby are being morally or going against their morals by supplying that insurance. They're not using birth control. We're not forcing them to use it.
Right. Well, the difference. One of the things the Supreme Court did there is that it really focused on the fact that Hobby Lobby was a closely held family corporation, which I think kind of punts the real issue of whether a corporation as a whole has the right to deny any kind of benefits on religious objections. And so they kind of looked less at the fact that it's a corporation, more at the fact that these are individuals running this company.
Even though it's a huge multi-million-dollar company. Right,
and they were saying that it's a closely held company that's only owned and operated by the family itself, and everyone else is underneath this family. Anyway, all that to sort of get to the point that they were dodging sort of the broader issue of whether a corporation can object on religious grounds,
right?
Because it's obviously more convoluted up there.
I mean, under those standards, Walmart is owned by like 6 people.
Yeah.
They could decide that they're Muslim and everybody's got to wear a burqa, and under that logic.
But isn't Walmart a kind of publicly traded company? Is Hobby Lobby publicly traded? Like, is Hobby Lobby a limited company, a PLC? I think essentially my argument would be actually to come down on Hobby Lobby's side, if that's true, is that there should be. I kind of agree with it. So we had a similar case to what you were saying regarding the religious liberties of small business owners. Essentially, is we had Asher's Bakery here in Northern Ireland, and the UK Supreme Court actually ruled against them. So it said that they had to provide services for this particular gay wedding, I think it was at the time. But I was wondering if a good way to kind of solve the issue is to make a legal difference between your mom and pop flower shop being run out of their front porch and Walmart, which is a massive publicly traded, I'm assuming, limited company.
Maybe, yeah. And I don't think Hobby Lobby really got to that extent. But I think one of the differences between Hobby Lobby and Employment Division v. Smith, just to your question, John, is that Employment Division v. Smith really, that dealt with an action that 2 Native Americans were doing that was expressly forbidden by law. Whereas in this case, we're talking about whether you force people to do something that violates their religious beliefs. And I grant you that this might just seem like 2 sides of the same coin, but Smith was getting at this dangerous substance that was harmful to human health, and you have this generally applicable law, and you'll forgive me for not having the exact legal definition of that offhand. This generally applicable law was designed for a public benefit. It was designed to protect people from themselves, essentially. Whereas in this case, Hobby Lobby, you're looking at these people who are being forced to do something that violates their conscience by the government.
Essentially, you're saying that it's not neutral.
No, I mean,
birth control is not a neutral thing.
Right, and there's something to be said about saying you can't do this even though it's in your religion versus you have to do this even though it violates your religion. I think there's some difference there. Because we do limit religion sometimes. You can't sacrifice your children.
Right.
You can't sacrifice. Well, you can sacrifice animals actually.
That's true. You can.
There's a case out of it's got a wacky name, but it was a free exercise case, and the government basically prohibited this weird Church of the Hialeah or something like that.
Yeah, I remember.
Yeah, they were trying to say you can't do that because it's creepy. I mean, let's be honest, that's really what it's about. And yeah, okay, that's creepy, but they said no, you can't do that. You can't just America. you can't prevent people from doing that. But I digress once more. And so Hobby Lobby, it's really about these people they object on a moral basis to providing contraceptive care because they view it as violating their personal religious beliefs. And so when faced with the Hobbesian choice of either leaving the business or leaving your religious beliefs behind, that's an unfair decision. And I think Gorsuch is going to come down very similarly. You're going to see him very friendly and very amenable to those arguments.
All religions.
Very friendly to religious liberty.
All religions.
Sure. But you don't usually see other religions having these kinds of issues because their deeply held beliefs aren't usually a controversy.
Like what?
What I'm saying is the issues that are coming up right now usually concern Christian beliefs because there aren't that many religions out there that take offense to homosexual ceremonies. Of course, Islam is another one that does, but you don't ever see in the media the fact that there are tons of Muslim bakeries out there that are turning down customers for gay weddings. They just never make the media. The only ones that actually go to trial and the only ones who are actually sued are the Christian organizations. And I know that you don't want to talk about whether people are targeting Christians, but
I don't mind talking about that. We can talk about that all day.
There is a discrepancy between lawsuits brought against Christians versus Muslim bakeries,
yeah, because
Jewish
there's a
bakeries.
discrepancy between how many Christians there are and Muslims there are. If Muslims were 80% the majority of the religion in the country, absolutely, it wouldn't be targeting Christianity.
True. But just on your point about whether it's all religions, I think it is. I just don't think you're seeing other religions get up to that point. They're not being sued. You're not seeing any Muslim bakers sued for refusing gay weddings. But they do.
And I think that is wrong.
And I'm glad you're consistent.
Absolutely. Well,
and I'd never accuse you of being inconsistent. We've had many discussions about these kinds of issues, and I know that you're the same, whether it's Christian, Muslim, or, flying spaghetti monster. Like, I get that.
No. You cannot criticize this flying spaghetti monster. He is our Lord and Savior.
Okay,
Hallowed
that's
be his
blasphemy. Oh, God. Let me ask you a question, John.
Go ahead.
Should a Jewish baker be forced to bake a cake with a swastika on it? If a Nazi German goes into... What was that case in Illinois? What was it called? It was that case where the Nazis wanted to march.
Yes,
and they
wanted to march through a predominantly Jewish neighborhood,
right.
and they were allowed to.
So, what would you say if a Nazi sympathizer went into a Jewish bakery and wanted a swastika on a birthday cake, or not a birthday cake, a swastika on a cake that was to be used at a celebrational event supporting the Nazi cause? Should that Jewish baker be required to bake that cake?
No.
Why not?
Because Nazism is an ideology. It's not an immutable characteristic.
All right, yeah.
No, seriously.
No.
You're not born a Nazi. You can choose not to be a Nazi.
What if you are so convicted that is the truth? That you're faced with the impossible choice of being denied your services and setting aside your personal beliefs. How can you say that person doesn't have a right to their beliefs on that?
They have a right to their beliefs.
And keep in mind, I'm talking about an event. I'm not talking about someone who identifies as a Nazi. I'm talking about for a Nazi event, whereas the issue that's before the courts is gay weddings, the specific event. Like Arlene's Flowers, where the woman served the gay couple for years, but only refused when they said, "Can you provide this service for our wedding?" And so, drawing a comparison between the wedding and the Nazi celebrational event, what's the difference? I just think that you have to conclude that if these bakers, florists, what have you, if they are to be forced into this service, I think you have to conclude that the Jew has to bake the Nazi cake. I do. I genuinely do.
That is going in the
And I don't think that either the Jew or the Christian has to make any of these cakes, because there are plenty of businesses out there that will do it. And I get that that's not a constitutional argument; it's a policy argument. And people make this argument all the time, and every time I hear it, I'm like, that's not a legal argument. But it's true. So if you're looking at it from the perspective of can these people get the service they're looking for, the answer is yes. They're only looking for a fight. So I think that the Nazi who goes to the Jewish bakery is looking for the fight. Just like the Nazis in that case that for some reason we can't remember the name of, even though it's a really famous case. Yeah. Just like they were looking for a fight. I know, right? Oh, God. You have nothing to thank for that.
I know. Yeah. I like that. I like that. I mean, it sounds awful, but I am a free speech absolute.
I am a free... Oh, okay. I'm a free speech advocate myself. Of course,
I will punch people in the face.
I'm in favor of some prudence. Like, come on, why did it have to be this case?
Okay, so yeah, I mean, I guess to be consistent, then I would say that if we're going to have a law that requires making a cake for an event, no matter what, if somebody's paying for you, then yes, you'd have to do it.
Okay.
I mean, it's going to suck. I have to do...
But my question is, why should that be the case?
Well, I have to do things I hate doing all day long.
This is America, though. You have the freedom of expression, which means you have the freedom not to express.
Personally, yes. But if I'm running a business of public service, then no.
But why does adding money into the equation, a personal business, why does that suddenly change the calculus? What is it? What is the magic thing about money? Paying for the service that makes it so that you can't...
enter into a social contract that you're not going to You are there to give your business is there to give services to whoever comes through the
door. Don't I have a social contract
you.
With you in civil society not to discriminate against you just as a person? I mean, what is the magic thing about a personal corporation? Why is that suddenly on what constitutional basis is this business? Because it's a business. You're doing it for money. Why is that suddenly? So
here's the thing. So if I hate a certain race and I don't want them in my house, then I don't have to have them in my house. If I knowingly start a business to service the public, that's what it's there for. Mm-hmm. Then I don't see why I should be allowed to pick and choose who I give service to if they're going to pay me for it.
I agree with you on a moral level, but I think that the best way for society to function in America is to drive that business out of business. I think that they honestly, and I know you're going to hate me for saying this, I think that you should have the right to do that, but I think that you and me have every right to drive that person out of business as quickly as we can.
Okay, yeah. So I would, you know what, I think I would agree with you there.
Okay. But
then you cannot cry religious discrimination when somebody runs you out of business for not making a cake for a gay wedding.
Right, but you shouldn't use judicial process to do that. Mm. If you and me and Adam want to go and drive a baker out of business for refusing this particular customer, that is civil discourse in action. That is public debate in action. And if they go out of business, so be it. You don't have to go to them for their services. And if that drives them out of business, then they can't force you to buy from them. I just think that we need to err on the side of freedom. We need to err on the side of allowing as many people as possible to enjoy the right to protect their own conscience. And I think that if you have bona fide beliefs, then you're not going to have people. And I grant that it's really difficult to determine when something's bona fide, but I think that you're risking pitting people against their particular God. And you're risking forcing people to choose between not just their religious beliefs, but their God. And maybe they're wrong. Maybe their God is not true. Maybe, whether it's a Christian or a Jew or a Muslim or whatever, maybe their religious system is flawed. But in their mind, they're going up against eternity. They're going up against consequences for their actions on earth. Mm. And you're making them choose between those consequences in their business.
So then should we allow Sharia law courts?
No, absolutely not.
Why not?
Because we don't have a system of laws that is tied to a particular religion. We simply allow them to exist.
Right, but not in many cases not adhering to that is an eternal issue. So if you're going to use that justification for gay wedding cakes, no, but my question stands. So if you are going to violate somebody's religious sensibility. So why not just violate them all? I mean, like you have. Well, I don't know if you believe in the separation of church and state, but the fact of the matter is that there is no mention of religion in the United States except that the state should have no part in it. So it's a hard sell to me to give these special rights to non-religious people. If I wanted to do the exact same thing for a non-religious reason, then there's an issue.
Well, I think the First Amendment says that Congress shall pass no law respecting an establishment of religion or prohibiting the free exercise thereof. Yes. And it doesn't come with qualifications. Obviously, the Establishment Clause is a separate issue. But I think that, and it's a composite of my personal opinion based on cases I've read, but I can't really give you specific citations on it, but free exercise of religion should be respected until it affects the physical safety of others.
Just the physical safety.
I think so. I think that if you use Sharia law as an example, and so I'm assuming that you're talking about women's rights violations that come under Sharia law and other things like that,
or for homosexuals.
Sure, and there are obvious concerns there, and I would say that as soon as you start messing with other people's physical safety and their well-being in society, I think that is where you have to draw the line, which is why when I said earlier, we can allow animal sacrifice for your religion, but we're not going to allow child sacrifice.
Right, but not allowing women to drive, not allowing them to wear certain clothing in public, that doesn't affect their physical safety.
Their freedom.
But it doesn't affect their physical safety.
No, so maybe, and again, I apologize for using very limited, this situation only kind of language. As soon as you start infringing others' ability to live freely in society, I think that's where you really have an issue. But the fact is, by refusing to make someone's cake, they have the freedom to go to another baker. They have the freedom to go to another florist, get another photographer. You don't need to force this particular photographer or baker to service you.
Isn't there a problem then if you're in a particularly, say, pro-KKK part of the country, and you have a white nationalist running a bakery who, doesn't particularly like African Americans coming in and doing business with them, isn't there then the risk that fellow white nationalists will simply just prop up the business? They'll actually advocate and support the business because of the particular beliefs that business holds, or the businessman holds it. Well, so for instance, was it Chick-fil-A? Ended up having, their business supported when they came out against, was it gay marriage at that point?
Yes.
So they actually had their business supported by people that agreed with them. So presumably it could happen in these perhaps more controversial cases as well.
Yeah. So I'll respond to your question with Chick-fil-A as an example, actually, and it might not be a perfect analogy, but I think this really comes down to the marketplace of ideas. And if you look at what happened in Boston after Dan Cathy came out against homosexuality and gay marriage, he was looking into expanding into Boston. It would have been in City Hall Plaza, and it would have been amazing. He was bullied out of Boston by Mayor Menino at the time, right? Yeah. So Mayor Menino sent him this, for all of his mumbles, and he brought together one coherent letter and basically gave the finger to Dan Cathy and said, "You're not welcome in Boston." But it's like, first of all, it's not the government's duty. It's not the government's right to say that this idea should be favored over others. That's the right of the people. That is the province of free marketplace of ideas to accept some views and reject others. But once the government steps in, then I think you have First Amendment concerns, because all of a sudden the government is favoring certain views over others. And so taking that element out of the analogy, and just let's say the people of Boston rejected this particular viewpoint, I think that's how the First Amendment is supposed to work. I think Dan Cathy backed away from Boston. I think it sucks for people like me who love Chick-fil-A, but that is sort of how things are supposed to work in this country. If you don't like an idea, you reject it, and eventually it loses in the marketplace.
The moral failings of the ownership of Chick-fil-A aside, Chick-fil-A is awesome. I love their food.
I agree with everything you just said, except for their moral failings. But just to tie that to the example that you gave of that KKK intensive area, I don't have a perfect answer, because I know that the comfortable answer is, you know what, the KKK should be prevented from doing that. That's very wrong. And I agree with you in real time. It's wrong for them to discriminate based on race. I just have a hard time justifying any government action that would force them into compliance with another idea, because I don't think that the First Amendment allows for that. I just don't. And I think that what needs to happen is that this society of people that, they're racists, they're the KKK, white supremacists, however you want to group them in there, that idea needs to die off. And not in the sense that we need to crush them under the weight of the law, but the ideas need to die. They need to be won out over other ideas. And people need to convince other people that those ideas are wrong, and that they should not proceed to the next generation. And slowly over time, ideally, you're going to see fewer and fewer people adhering to that belief.
Ideally, the problem being that, in particular, the resurgence of Trump, suddenly ideas like white nationalism have voice again, that they're in the public discourse again in a way that they haven't been for a good few decades. So I would like to agree with you, but I think it's idealistic.
And Adam, you feel that same way about things that I have said. Episode 3 on whether you should punch neo-Nazis or if you should let Milo Yiannopoulos speak at universities. I took a very absolutist position on free speech, and annoyingly enough, I agree with you in this case.
Interesting.
So I would say that the best way to get rid of bad ideas is a freer marketplace of ideas.
Yes.
And so if that means allowing Milo Yiannopoulos to come to your college and embarrass himself, and you have somebody else there ready to refute what he has to say, in that way, I don't believe that we should be limiting speech. The only thing is, though, is that, the KKK is...
We all hate the KKK.
Well, we all hate the KKK, obviously. But the KKK nowadays, obviously, has much more bark than bite. They used to be much more powerful.
Right.
They used to have politicians, and they used to do physical violence. In those cases, that needs to be absolutely stopped. But the rhetoric, you have to fight proportionally to what's being done to you. If they're using rhetoric, you use rhetoric. If they're using force, you can use force. That's my opinion on it. So we do agree there.
Mm-hmm.
I know Adam disagrees with me.
Yeah, essentially I'm not an idealist when it comes to people. I don't think that poor ideology or hate in general goes away in the free market of ideas, for instance. And I do think it is worthwhile actually defending your core principles and values if you have such a system. The problem is in America is it seems that no one can actually decide what the Constitution actually means, and so you get this history.
That's true. So we appoint 9 unelected judges to lawyers to determine what the Constitution says, and sometimes they get it right, sometimes they don't.
Well, right, and the fact that you can say, well, sometimes they get it right and sometimes they get it wrong is just kind of a testament to the fragility of the system, even under a constitution. And so, I would love, in an ideal world, to have complete and absolute free speech, but there is I do wonder if there's a point in which we do have to protect the fundamental principles of our society, even up to and including some speech.
Right. So it reminds me a little bit of the Jean-Jacques Rousseau, who would say that whoever disagrees with the general will would be forced to be free.
Rousseau was also imagining communities of maybe a few thousand people at the most as well. So
that's the problem. America's too damn big.
I agree completely.
Which is why in a lot of issues I would be much happier if we deferred to federalism. But the problem is that you have states that will legalize segregation.
I don't think that's true. I genuinely don't think that's true. I think there's racism in the United States. I do. I just don't think that you're going to get enough racists.
We had it.
You might be able if you took every racist in the United States and put them in Rhode Island and took all the people of Rhode Island out of Rhode Island and put them somewhere else, then all of a sudden you have this one little state of racists, and you might have a couple of thousand there. Hopefully that's it, but yeah, then maybe
a couple thousand out of 350.
I don't know.
Million.
I don't think I would not. I would dispute.
Then let's put it in the historical context. You needed the Supreme Court,
yes,
by judicial fiat to say no, you can't do this.
Yeah,
we needed that at some point. Maybe we don't need it now, but we needed it at some point.
Part of Atlanta Motel, Brown v. Board.
Yeah, exactly. So if you don't have that standard where there is an ultimate law that does trump state law, you're not going to be able to guarantee that justice is always done. Not to say that in this system that justice is always done, but I think you're closer. I mean, we can all agree that Brown v. Board of Education was the correct choice.
Absolutely.
And justice was served in that instance. I just think that yes, you allow the states' rights up to the point where you have to have the room for justice.
Right. And in that particular case, I mean, it really did come down to the 14th Amendment, which was passed by Congress and passed by the states, which guaranteed equal protection under the laws. Yeah.
Ostensibly, but then we have issues about gender identity and sexuality that are hazier.
They are hazier, and it gets a lot more difficult because you're dealing with a lot more complex issues like transgender bathrooms, for example. Mm-hmm. And that isn't really a simple matter of, as much as some people want to paint it this way, it's not a matter of separate but equal under Plessy, which was overruled by Brown. And so there's a different dynamic at issue there. And so it's hard because you have to figure out how to analyze these issues in light of the historical context of the 14th Amendment, of the segregation case. It is hard to bring these into the narrative.
Yeah.
We see over time that the Supreme Court is enlightened as to what is the right course of action. I mean, there are many infamous cases decided over the years that were eventually overturned. Plessy versus Ferguson, Dred Scott versus Sanford. Horrible, horrible cases that discriminated or determined that people were essentially property. And they were justified, attempted to be justified on constitutional grounds. But then you see shimmering lights every now and then. In the Plessy dissent written by Justice John Marshall, he really echoed a lot of what became the majority opinion in Brown versus Board, and upon which Scalia today, as he would have said, was really the light in which originalism can be used to justify Brown versus Board.
So then, I guess my question to you then, is there any, do you view that sort of as a natural evolution of case law that does sort of adjust to society? And say in the future we get incontrovertible evidence that being homosexual is an immutable characteristic. Mm-hmm. Would you then say that something like Obergefell would be justified?
I think that, like I said earlier, I think that's one of the tensions that's underlying the issue still. I think it hasn't been resolved. But that wasn't the basis on which the case was actually decided. It was decided on 14th Amendment grounds. I still think that the proper avenue for that issue was the 10th Amendment, was states' rights. It should have been, the court should have left it to the states under the 10th Amendment. And the states, one by one, as Massachusetts did, as Vermont did, California, New York, you name it, one by one, should have turned to the issue and handled it in their legislatures.
So essentially, I guess you would say then that you leave these things that are in the Constitution to the states.
Correct.
And if there's a certain state that does it the way you want, move there.
More or less. I mean, but that's how the Constitution's written. The states have the right to pass these laws. They have the right to say, let's talk about gun rights. Massachusetts has certain restrictions on gun rights. I have to actually, if I want to get a gun permit here, I have to fill out a form that states my reasons for wanting to.
Yeah, I know. I've been certified to carry a gun.
Why do you have to give your reasons to the government for exercising your constitutionally guaranteed right? If you don't like that, you can move to another state that grants you more freedom, like Vermont. You need no permit up there. You walk into a gun store, you purchase. So my point is that in some states, it's going to be impossible to get a gun. It's going to be impossible to have your Second Amendment right, which is an enumerated constitutional right, by the way, as opposed to some of these other issues.
Debatable.
Fair enough. But if you don't like it, you do have to move to another state. And so it affects all sorts of different issues. It affects, in theory, not after Obergefell, but in theory, it would affect same-sex marriage rights. It would affect your right to purchase a gun. It would affect your right to get medical marijuana, all these issues. Otherwise, we can just have a federal government that completely swallows states' rights and regulates everything. Because on some level, you can always find something that you like in New Hampshire that Massachusetts doesn't offer you.
Then what do you do with the Supremacy Clause? Do you just throw that away?
No, absolutely not. But the Supremacy Clause only applies where the laws of the states or the state constitutions are at odds with the Constitution of the United States. That just comes back to how you interpret each statute and whether it's justified by the Constitution.
That leads to so much stickiness, though, because Obergefell that tried to decide based on 14th Amendment grounds. Then who's to determine whether a state statute violates the Constitution or not? Because the thing about the United States Constitution is it's horrendously vague.
It's true. And as time has passed and as you see, other countries, other younger countries, developing constitutions that are less... Well, for a while, as the American experiment worked out, people modeled some of their constitutions after ours. But, as time has gone on farther, you've seen them sort of expressly fill in the blanks where our Constitution arguably has its flaws, I guess, where we've needed to impose judicial interpretation. Others have sort of filled in those gaps.
Well, the problem with something that's open to so much interpretation is it borders on being useless.
I can see how that argument would be made. I just think that if you look at the Constitution as a framework, and if you look at a weak federal government that's sort of regulating these vague principles, I'll grant you that they're vague, over the 50 states. You have to look at it in terms of there being a small federal government. You have to look at it in terms of the emphasis being on the states and on states' rights. And there was a greater emphasis on the states in revolutionary times back in the 1800s.
Absolutely.
I would say that one of the moving chess pieces in that equation was the passage of the 17th Amendment, which actually it empowered the people to elect their senators. Before that, not a lot of people know that you couldn't actually elect your senators. They were appointed either by your state legislature or by your governor, or maybe even your congressional delegation. I don't even know.
Right. It wasn't
right.
Strictly democracy.
But the reason for that is because it gave the states the power to actually put in their own representation, because the Senate was never meant to represent the people. It was meant to represent the states, which is why we have two chambers and why there are only 2 senators per state. Otherwise, it makes no sense to have 2 senators per state, because all of a sudden you're giving incredible power. You're weighing like one person in Wyoming against like 100,000 people in New York. It makes no sense proportionally. The House of Representatives is supposed to be proportional. The Senate is supposed to represent the actual states. And a lot of that history got lost once we allowed the direct election of senators. And so the Senate was supposed to represent the states and thereby giving the states greater influence in the federal government. But it's really gone the other way, and we've seen the federal government have more influence over the states, and really, 50 states, they don't really mean as much anymore. I mean, they do, obviously, but they don't really mean as much whenever the federal government wants to step in and impose something on them. And it was never supposed to be that way.
I think they should just all go the whole hog and go for independence, all 50 of them. We should probably think about wrapping up a little bit. So, Chris, do you mind if I ask you a couple kind of quick-fire questions, really about Gorsuch, to kind of to finish up here?
Lightning round.
The lightning round of this conversation. So, the hearings are supposed to be starting today. What are the chances that it will be confirmed?
Very likely. There's been some talk of Democrats filibustering any Republican nominee, but the bottom line is that the GOP have a safe majority. As long as the majority leader can get his act together and invoke the nuclear option if he has to, Gorsuch should have no problem getting through.
What is the nuclear option?
Well, the nuclear option is changing the rules of the Senate so that a bare, simple 51-49 majority can approve a Supreme Court nominee, and as it currently requires a supermajority, I think, of 60, is it just 60 senators? Or 65? Something like that?
60.
In any case, it's a supermajority of senators, which the GOP does not have, I don't believe, to pass the... I forget how the exact numbers work out, but we don't have a supermajority right now. There's something to be said about the fact that in 2006, when Gorsuch was initially appointed to the 10th Circuit by George W. Bush, he was passed unanimously. He was a likable guy back then, and granted, that wasn't the Supreme Court. I mean, he was basically being put in a court that oversees like 50 people living in Colorado, and that's about it. This is a much bigger deal. His views have a much greater impact, and as we said earlier, he has more freedom because he's not as bound over a court above him because he's in the highest court on the Supreme Court level. So obviously there's going to be more resistance to someone who is more conservative. Nevertheless, you got to look at the fact that he is a very likable guy. He didn't go in with controversy, and he doesn't have controversy. And while his philosophy hasn't changed all that much over the years, there is also not going to be a lot of surprise there. And so people generally know what to expect out of Gorsuch. And so while there's going to be, you're going to hear the run-of-the-mill questions. What are you going to do about Roe v. Wade if that comes up? You know, everyone loves to ask that question. Are you going to be a vote to affirm this or reverse that? And everyone knows the answers to these questions going into it.
So how long will it take?
You know, it's always hard to tell. With Justice Thomas, with that controversy he had going on, it only took a few weeks. In this case, it's safe to say he'll be in there either early or mid-April, no later.
Right, okay. And finally, given that he'll probably not really change the dynamic of the court so much, essentially just stepping into the shoes of Scalia, more or less, it sounds as if the Supreme Court's going to be fairly balanced with kind of a middle-swinging judge in Kennedy. Is that correct?
I think so, yeah. You're really going to see us kind of return to where we were in February of 2016, just before Scalia's untimely passing. More or less, I mean, there's certain differences between Scalia and Gorsuch that might come out. One of the most pointed out differences is Gorsuch's position on Chevron deference. If you know, it's the administrative law case where Scalia authored the opinion and basically said that we're going to give a lot of deference to agencies as they interpret regulations. Basically, self-regulating authority to say, we think that this regulation means this, and no one can tell us otherwise. Scalia lived to regret that, but I think that's one example of where you're going to see a slightly different dynamic with Gorsuch in play.
Do you know of any upcoming cases, or are there any upcoming cases that he's definitely going to be an influence in?
I was doing a little bit of research on this, actually, and there was one case that was kind of a big deal that he was going to, if it hadn't been sent back down for reconsideration. That was Gloucester County School Board, which, as you may know, is the transgender bathroom bill case from, is it the Fourth Circuit? I think it's the Fourth Circuit.
I think so.
The Supreme Court just sent that back for reconsideration in light of Trump's drawback on Obama's Title IX transgender policy. So the court basically punted on it. So it's not going up for oral argument this term, but if it does come back, which it probably will, Gorsuch is absolutely going to have a hand in that. But as of right now, it's not on the near horizon. Another one that's worth looking at is Trinity Lutheran Church of Columbia versus Pauley. That's set for oral argument on April 19th. That's going to be pushing it for getting him in the door. It's a little bit less than a month away at this point. But that case deals with whether excluding churches from secular aid programs violates the Free Exercise Clause, or whether the Establishment Clause issue prevails on that one. And you can be absolutely sure that if he's confirmed in time to hear that case, he's going to be a vote in favor of free exercise on that one. So that's just a couple of things that are coming up this term. There really isn't a whole lot of other controversy before the court at this moment.
Right, but overall we can expect if things like money in politics come up, he's going to be more on the side of upholding Citizens United.
Yep.
He'll be more in favor of upholding decisions like Hobby Lobby, all of our conversation about Dormant Commerce Clause. So we kind of have an idea of where he'll go based on the fundamental questions underlying each case.
I think so. Yeah.
Anything that you would like to add yourself after this conversation? Any final thoughts?
I think that you can find a lot of hope by looking at Justices Scalia and Ginsburg. For those of you who don't know, they had one of the greatest relationships that you'll ever see among two colleagues, friends, two people who disagreed so strongly over almost everything that was before the court, at least of any controversial value. We can get a lot of hope from them, because if two people who are so polarly opposite on women's rights, abortion, gay marriage, money in politics, RFRA, all these issues, if you can find two people like that who disagree so strongly on every issue, and they vacation together, they hang out together, it's really encouraging to see that kind of relationship can exist amidst those differences. That is why we have things like the First Amendment that guarantees the right to free speech, and that's why this country is such a great place, because you can't see that everywhere. And more importantly, this is the place where ideas can clash without resulting in an intense amount of fallout. And so I take a lot of hope from looking at that. And I would just encourage anyone who's nervous about Gorsuch or about any potential future appointees to the court to just remember that we are a country of many ideas, and it's not the end of the world if someone you disagree with has an opinion that is heard a little bit louder at this point in time.
Said from the winning side, perhaps.
Did the victor go the spoiled?
There might be some degree of truth to that.
No, that is a great hope-filled way to end the conversation.
We need some more
to
hope
end the
today.
episode. Exactly, we definitely need more hope. Thank you, Chris, for joining us in this. I've thoroughly enjoyed it myself. I've certainly learned a lot. So
Thank you both for having me. I enjoyed it.
Well, we appreciate you coming on, and we would love to do this again sometime, maybe based on more policy issues than just discussions of the Supreme Court.
I'd enjoy that.
Great.
That's all, folks.
Well, that's it. Thank you for listening to this interview. We really hope that you've enjoyed it. We had a great time catching up with Chris. Remember that our news and opinion segment, Political Animals, will be in your feed every Friday morning, and the Commoners podcast itself every second Monday morning. Remember also to follow us on Twitter at CommonersPod. Again, thank you for listening, and as always, stay informed.